$884 in fines over a string of holiday lights. By the time the trial court was finished, the same couple had also been ordered to pay the association's legal bill, $39,148. Same lights, same dispute, 44 times the money. Then Virginia's highest court read the association's own recorded rulebook, and it reversed the entire judgment. This is a real case, decided by the Supreme Court of Virginia in 2019. A couple in Loudoun County, Virginia kept a string of lights on their front door and another along their back deck railing. The lights marked Hindu, Sindhi, and Sikh holidays, which run from around early October to as late as April. So they stayed up roughly 300 days a year. The association's rules did not just limit when lights could be displayed, they also required them off by midnight. The trial court found these were on around the clock. So that is the conduct: a modest display kept up outside the approved windows and left on past the curfew. The association had what it called seasonal guidelines. They set date windows for holiday lighting and the midnight curfew. Enforcement ran through the association's Architectural Review Board, not the Board of Directors, a separate committee. It held a hearing and imposed a fine of $10 a day for up to 90 days. Then it did the same thing again at a second hearing 2 years later. Which brings up the question that decides this case. Where did the seasonal guidelines come from? A board can write a guideline. That part is easy. The harder question is whether anything ever gave it the power to. Think of it as a stack. At the bottom, board rules and guidelines. Above them, the recorded declaration and covenants you agreed to when you bought. And above those, your state's community association law. A level can generally only do what the level above it allows. And one thing worth clearing up, because it trips up almost everyone. The Constitution usually is not on this stack. Constitutional rights generally restrain the government, not a private association. A few states extend their own state constitutions further. But as a rule, telling your board they are violating your First Amendment rights is not the argument people think it is. So the association's power to make a lighting rule had to come from somewhere real, the recorded covenants, or a statute. And the covenants did mention exterior lighting. They spoke about adverse visual impact and about location, wattage, and similar features. What they did not mention was a calendar, or a curfew. The trial court sided with the association. It upheld the fines, issued an injunction, and ordered the couple to pay the association's attorney fees and costs. The Supreme Court of Virginia reversed and sent the case back. The court held the seasonal guidelines exceeded the scope of the restrictive covenants and were not reasonably related to any of them. It applied a rule that shows up in courts in many states. Restrictive covenants are read strictly, and where the language is doubtful, the doubt usually goes to the owner's free use of their own property. The reasoning is older than any homeowners association. Your right to use your own land is the starting point, and a restriction on it has to be clearly established, not inferred. So here is the practical takeaway, stated carefully. When your association fines you, the rule being enforced usually has to trace back to real authority. Either the recorded declaration or power your state's law gives the association. Boards can and do adopt valid guidelines. The question is never whether a guideline exists, it is what it stands on. So, the move is simple. Ask the association, in writing, to identify the specific provision of the recorded declaration, or the statute, that the rule implements. Then read it yourself. Often the rule is properly grounded and the fine stands. Sometimes, as here, it turns out the association was enforcing a standard it wrote for itself, with nothing behind it. But one caution. These owners won, and it still took an appeal, and for years they were the ones holding that bill. In many states, the losing side can be ordered to pay the other side's legal fees. That risk runs both directions. Rules and procedures vary widely by state, and this was a Virginia decision, so check your state and read your own recorded documents. Educational, not legal advice.